morning.
Good morning. How are you?
I'm nice and cozy and warm. How about yourself?
Oh, it's freezing. It's absolutely freezing cold out there, isn't it? First day back in the gym. That's nice.
Yes, mine's tomorrow. I'm not looking forward to it, but it's the necessary evil.
Now, look, we've got a lot on today. It's International Men's Health Day, so we're going to give you a little bit of data around that. There's been some minimum wage changes, range of different cases. So we're going to jump into it because we've got quite a lot on today, much more than we normally have. In the next week, we'll publish an article on men's health. We've got Tom, who's our business analyst, to look through all the most recent data around men's health. I guess, Karen, not surprisingly, the guts of that data falls into these things. One, men are about a third more likely to report health, particularly mental health related issues, than women. They are twice more likely to do something quite serious about their mental health, like take their own life. Their health outcomes are significantly worse than women because of the slow reporting nature. The drivers that sit behind that failure to report, and I guess we're talking about this today, to honour what International Men's Health is about, and really it's about saying men don't do well with it. Mm-hmm. But as an employer, we're talking about it. So now that I know that men have these inherent risks, why do they behave like that? Well, they behave like that because of a particular stereotype of what men are, which is stoic. And for those who talk about man flu, they may not believe that, but that men's perception, they've got to be stoic, they've got to be self-reliant, they're not allowed to complain.
Can't be vulnerable.
Can't be vulnerable. So some really good indicators there about what is the strategy that we use. But the thing that we see with men about how that starts to play out in mental health is, again, very different to women. So we see men becoming increasingly irritable and aggressive. We see a dramatic uptake in alcohol and drug usage, which is a particularly male set of behaviours that exist behind it. And we see that in the beginnings of absenteeism, not as in taking days off, which is much more a thing that women do, but in being late to work when they're traditionally not late to work. We see it in dramatic drop-off in productivity and quality, and in the resentment in being performance managed. So we'll write this quite detailed article. Tom's pulled around about 40 or 50 articles, and we've got from Mark Cassidy all the EAP data about men's access. So we'll put that in an article for you, because I think having information is really helpful about this topic. But it comes to the strategies of, well, the law tells us we have to monitor health and provide a safe place of work, and that you must do something. This is safety law, employment law, also. You must do something when a reasonable person can observe a person's unfit or unsafe to do their job. But it's all too late with men when you get to that stage. Yeah. It's more around the performance issue that you have to start moving straight away. And I think that's something you should really talk to. It's more your game than my game.
Yeah, look, I think when it comes to mental health, and I know today we're talking about men's mental health, we need to accept that it is a workplace issue. It's not something that we're dealing with privately, even though there's still that kind of understanding or the belief that, look, it's not our issue, we don't know about, or people don't want to talk about it. No, if we do, and with those statistics and the research that's been done around this, it is an issue that employers need to actively manage. And part of that is in terms of all the barriers that we're aware of and how it's more difficult for men to come forward and seek some support and help. The question is, how do we make it easier for that to occur? We don't have the answers all here, but it's a conversation that needs to be.
And I think, Karen, in our firm, there are weekly check-ins with all staff members. Why do we do that? Because we found annual or quarterly or 6-monthly reviews were completely ineffective, and they're inclined to be punitive rather than growth-based. But it also meant we didn't have an accurate baseline of what good health looks like.
We know when someone's a bit off, right? They start to,
And so we have those discussions. And look, what I'd urge you to do is to look at performance as the key indicia of mental health. Why? Because it makes business sense to always have good performance. And B, you hire good people. So if their performance changes, it's usually something driving that. And that's a great time to start having those conversations. Yeah. But men will rebuff that conversation. And that's why the performance conversation is so easy, because you say, look, I hear there's nothing wrong, but this is what I'm observing. And I'm going to keep observing, and I'm going to come back. And if it doesn't improve, we're going to have another conversation. And what I'd urge you to do is talk to me. Anyway, let's move on, because we've got a lot going on. I also promised to you last week I'd give you a case or two around
what is it? HR managers behaving badly.
That's right. And probably the best known one is Robinson and Imperial Mushrooms, where a mushroom worker who'd been in the business for a long period of time put a knife down somewhere, couldn't find it. Business formed the view that he'd knocked it off. He came back and was able to locate it, but the HR manager who did the final interview had already written out the termination letter, rushed them through, terminated the employment, and the court was just so critical, naming the HR manager in it about this role of an HR manager. And can I be really clear? An HR manager is a really difficult role because you are two different people, but you are the controller of values inside the organisation. And you'll often be presented with operations saying, look, I'm just sick of Karen, get rid of her. And they've spent 2 years not managing her, and then suddenly tomorrow they want to terminate your employment. Well, that's actually not your job. Your job is to be objective, to be fair, to drive a fair process, because it's something that resonates throughout the whole business about how values goes. It pushes back onto operations what their responsibilities are about managing people. And you are the truth teller in the organisation. And if you're not, nobody trusts you. And therefore, all the things you want to do about building capability and growing people, all gone because nobody trusts you. So I could find another 15 cases without too much effort, but I just thought such a simple case.
Yeah.
Good example. Now for our cases for the day. So that wasn't really the case of the day, but the first case is around resignations. And I think a lot of us have had people in the heat of the moment go, that's it, I'm resigning. And the next day they've gone home and seen their partner and they come back with their head down and go, no, I withdraw my resignation. So in Harvey and Valentine hydrotherapy pools, a person who'd been a volunteer and then a casual employee raised an issue about underpayment and started to fall out, and one of the board members made the comment, well, you know, you get paid, but you're always on your phone, so that's why you're being paid as you are. Now, this was an unfair dismissal, by the way. This is a perfect adverse action claim because that was a workplace right. The employee, Harvey, got so distressed by it, said, I've got legal advice and I'm going to be resigning. And then the next day wrote, I've got more legal advice and I'm not resigning. And they, of course, sent a letter confirming they accepted the resignation the day before. And what the court said is there's a lot of difference between I resign and I'm going to resign. I'm going to resign triggers resignation. And except, and this is a body of casework, if it's done in the heat of the moment, the court will allow a cooling off period. And if you sack someone within 24 hours from a heat of the moment, you know, middle of an argument, they go, that's it, I'm leaving. The court's always going to reinstate them. So the answer that came out of this case, and that I want you to learn, I guess, for me, is when someone is in the heat of the moment, always be respectful for them, always confirm and say, look, we had a discussion. It was an unfortunate discussion. You said you've resigned. I've accepted that resignation. If you change your mind by 7 o'clock tomorrow, let me know. Otherwise, I'll arrange your payments and things, and we wish you well. Do you see the difference? It gives the person a chance to come back. You don't have a $20,000 fight and the person's forced to be reinstated. It also allows the person to say to the organisation as a whole, because they'll talk to everybody else, actually, I was dealt with fairly. Remember, every time you deal with a dispute, you have a set of stakeholders that you've got to remember. They're your own staff. And as difficult as a person is, at the most difficult times, if you behave badly, Australians as a group, no matter where they come from around the world, Australians as a group don't like bosses asserting power unfairly. I mean, that's just the truth.
Yeah.
So that's a really short little case today to remind. We've got another short little case, which is about how to engage experts, which is Telcel and Lessie. Again, the case is not completely on point, but I just loved it because it raised an issue which I constantly see as a problem. This was a case about an injured worker. Telcel hired an expert to give advice on it. The expert said, yeah, there was a sort of causative link between the accident, and therefore this became a common law claim, a workers' comp claim. And of course, as soon as the common law claim was lodged, the expert, after having discussions with Telcel, none of which were disclosed, within the second report said, no, I don't think the connection is there for causation. And the court said, well, what evidence changed your mind? So can I just go through the lessons about engaging an expert? Both of us in our different businesses are meticulous about hiring the best expert, not the one who's going to agree with us. And the reason for that is because we're good people. And we want to do the right thing. We're trying to find out accurate information. We never put a narrative inside a request for a report. We're never trying to influence, whether it's an investigator, whether it's a doctor, we're never trying to influence them. We're just trying to get truth. We always put in all the evidence, not the evidence that suits us, and we don't put in evidence we're not allowed to put in. So if it was a termination of employment, we wouldn't put in workers' comp records because it is an offence under workers' comp legislation, every state and territory to do it. So this case basically said at the end of it, look, I see the doctors changed their mind, but I can't see the evidence. And it came from the Commissioner Allison, the head of the Workers' Comp Commission. He's a really capable woman who said exactly the same thing. And then Rob Pearce, who's the judge, again, a very capable judge in Tasmania, said exactly the same thing. I can't see the evidence. You changed your mind, but I can't see the evidence. So can you just remember, don't try and do stuff with sleight of hands with experts to get the outcome you want. That's probably cost $80,000 to $100,000 in legal fees. And you're lost. Whoa, how bad's that? How bad is that? And look at the damage you've done throughout your workforce after that. Okay, so really interesting case. National minimum wage came through 2.5%. CPI is around 1.7%. So there's been a growth, and that's a recognition that despite the noise that's been made about our great unemployment rate, underemployment is terrible at the moment. It's much higher than it's ever been, which means there's more people in work, but they're not doing as much as they want. People are poorer at the moment.
Yeah, absolutely.
And they've suffered a lot financially. So the full
you don't hear that though.
No, we don't. We just hear the spin.
Yeah.
But the Commission together all said, look, 2.5 is what we need. What they've done is they've staggered that. So for things like retail, it won't be till 1 September. For airlines and another 20 awards, it won't be until I think October or November. We'll publish the awards that are affected for you as to the days that break out on. It's not really the big issue today. The big issue today is there will be those of you who have utilised awards underpinning what people have paid, and they'll be topped up over that award. And the issue is, do you have to pass that 2.5% on or not? And the answer is it's your contract that will tell you the answer to that. So be cautious about it. If you need a bit of a hand, just ring Matt or Nina or Ness or Julia, one of the guys in our team, and they'll give you some quick advice on for nothing. Just give us a call to work out whether you do have to pass on or don't pass on, because it is a matter of contract law as to whether you do or don't.
Yep.
All right. Now we're to our major theme, which is out of hours conduct.
Yep.
Karen's got another information graphic. Before she gets there, I thought I'd have a quick chat, and then I'm going to shut up for a while. What authorises us to do an investigation is always the same things. The common law right to ensure that people act in the best interests of the business, and act with care, attention and skill. Okay, they're the things that sit beneath us. So if someone does something that's not in the best interest of the business, and you've heard last week what are the 3 tests from Rose and Telstra about out of hours conduct, is it ultimately the question is it inconsistent with the contract of employment you've got, your out of hours conduct? So the common law gives us that right. It should be in your contract, and it should be in a policy that says specifically and in great detail what it is out of work and what is not. Otherwise, you attract other liability. So if you have an all-embracing out of hours conduct, suddenly you're liable for workers' compensation and damages claims for things you shouldn't be involved in. So it needs some skill in crafting those. Okay, so that's where your authorisation comes. The big question that came out from you last week, well, what happens when someone does do something wrong? Can we suspend them? Sometimes called standing down. It's actually suspending someone on pay. Up until relatively recently, the rule is the common law didn't provide you with a basis for suspending someone. It must be in your contract, and it should be very clearly. Now, can I just say to you, it must be in your contract. I just want to be clear about that. If it's the right of suspension is not there, you end up in what's called a VENIA and the Road Transport and Health Fund argument around whether there is an implied right in the contract to protect the safety of people or to ensure the integrity of an investigation. And we're going to talk about this more next week about out-of-work criminality behaviour and what we do with that. But the answer is the common law's extension is probably only this far, and that is where it is a genuine safety risk to other people, and possibly where it could undermine the integrity of the investigation to stay. So can you please put it in the contract? Now, Karen, I'm going to hand over to you at that stage.
Sure. So can you load up the slide, please? So what I've got for you today is a couple of things, a couple of pointers when considering how it is that you manage out-of-hours conduct. So spelling it out really simply for you.
You looked at me when you said that.
Well, simply, this is okay. I won't look at you again. I'll try and be more discreet next time. So firstly, out-of-hours conduct. In terms of the evidence around this, you need a couple of questions you need to ask throughout this whole process. Is firstly, what are your out-of-hours risk in terms of, for example, there's social media risk, there's the travel, the functions, work-related, non-work-related as well. But where do the risks actually, where are the sources throughout your whole workforce? So typically it could be, for example, your project team who have to travel a lot throughout the country to meet with clients, it could be your sales team, it could be, so it's think of it comprehensively in terms of where are your exposure points. What incidents have occurred in the past? This is really going back to evidence. What kind of problems have we had previously? And what potential problems do we know about as well? So where we haven't had incidents, but we've heard murmurs, we've heard anecdotal, comments around, look, these things being problematic, you need to pay attention to those.
Isn't this a problem, Karen, that before people create plans, they're inclined to take something off the internet rather than go to the evidence and actually look at your organisation and analyse where its risk is, to spend time thinking? Most of the problems in work-related issues are that people don't think. They actually treat it like it's a side business. So I just raise that because it's common for us, people saying, can you give us a template? And we go, yeah, I can give you a template, but it's not going to actually deal with the risk in your business. Your obligation under safety law is to
doesn't stop you from asking
risk assessment.
It doesn't stop you from asking these questions and answering these questions for yourself, right? So in terms of where these risks are, what are the impacts of the risk? High, medium, low. So assessing those, and through the evidence, the pool of evidence that you have, creating a strategy and a plan which allows you to create controls that would be appropriate for each risk profile across your group. And when it comes to process, have a look at your framework in terms of what are the supporting policies, documentation, and processes that you have to manage the risk currently. And also, how is it that your workforce are informed about what the expectation is, but also what to do, okay? Because I had this conversation with a client yesterday. You can have all the policies in the world and they can be absolutely impeccable and wholly comprehensive, but if people don't understand them and know what to do, then they're ineffective, okay? They don't work. And as a result of that, what's your compliance like? How do you monitor compliance as well? Training is obviously a huge part of this and ties into my last point, making sure that with each risk profile of your workforce, how might your training needs differ across each group or segment, and what training support is required for these people or these groups. And again, how do you demonstrate competency? Because knowing versus doing and understanding are completely different things.
Can I just say, and that comes to the last point, that you train based on risk, but you also train on immediacy. So if Karen's going away with a group of people on a field trip, then I am going to actually send out a quick questionnaire that says, okay, here's the policy, tell me what's the plan you've done, how's it going to be managed, so that there's an immediate understanding. It's front of mind. I'm about to do this. These are the risk factors. How am I going to manage them?
Yep, absolutely. And yeah, going back to managing, so comes back to your manager's skill set and competency around their knowledge, but also ability and skill to be able to manage these type of incidents or concerns as they're raised. And certainly in terms of monitoring compliance, but also performance against this area. What does that look like at the moment? How is it that you've learned from what's happened last year so that you're improving the way that you're monitoring and managing these risks this year?
And ultimately, we want a report back. So we want to, once you've got a plan, the most important thing is we get the metrics that come back at the end to improve what we're doing, learn from new bad experiences that are good or good experiences.
Well, absolutely. You're going to fail. You fail forward. And I will say about this topic, as with all matters that relate to people management and risk, is it's very simple, but it's not easy, guys. So it takes, again, time to really think, gather the evidence, plan, speak to the right people, form the right strategy, and get and set up the right framework to support you. Yeah, it's not about more work for the sake of doing more work. It's more work to be actually protect your people in your business.
And the last part is do something.
That was it.
Yeah. Okay. Very, very good. Well, let's go on to the more hastily written case study this morning, because I actually forgot to do it and was sitting at my breakfast waiting for Karen. So this is the case study for today. Vincent is a senior counsellor for Bridge Life, a church counselling service for men struggling with violence and family breakdown. Vincent has a written contract but no requirement to make disclosure of criminal offences he is charged or convicted. One Friday night, he went out with friends from work. He was struggling in his relationship with his girlfriend, Sarah. Now, that's good. Sarah didn't have a name when I wrote it out this morning, so thank you, Sophie. When he got home, he was very drunk and Sarah was angry with him. Vincent became angry, lost control and struck her. Sarah called the police and he was arrested and bailed the following day. Sarah made a complaint to his work about his behaviour. She said, given he works with young men with alcohol, drug and violence problems, they should seriously consider continuing his employment. She got an intervention order stopping him from coming near her. Okay, now I think that's only one page because I did it this morning. So let's go to the poll. There we go.
Very simple case today.
Very simple case, yeah. And we're running ahead of time because of that. That's probably when we need advertisements, really, isn't it?
Might give it another 10 seconds, Andrew.
Because we're 20, we've got plenty of time.
Yeah. Okay. What should we talk about? For the second week, we're wearing the same clothes. We're trying to hide that.
I know.
Last week, we're both wearing grey skivvies. Today, we're both wearing black skivvies. So can I tell you next week not to wear a skivvy?
Yeah, okay.
All right, let's wrap this one up. I think we've got pretty much most people in already. So, all right. Let me just close that off. All right, guys, let's look at the results. All right, can you see that, Andrew?
Yeah, Mark's asked a question.
Yeah. Is the House and Look See Netflix show?
What was that?
Oh, I think he's referring to a show.
Oh, right.
Yeah.
All right. So, look, the first question is Vincent required to disclose his police charges to employer when there's no contract. Interesting. We've got answers all over the place, and that's not a bad outcome. Certainly, if the contract required disclosure, he would be obliged to. So you're getting my point about how important contracts are at this stage?
Yep.
Privacy legislation and discrimination legislation has certain protections that sit around criminal behaviour. For instance, if this was if this was an old conviction and was called what's called a spent conviction, he'd be under no obligation and we would not be able to ask about it. But what's his common law obligation that sits here? His common law obligation is always act in the best interest of the business. If we look at Rose and Telstra and the third limb of Rose and Telstra, it is to not do something that is inimical or so obviously in breach of what his contract of employment. Could he come back to work and do his job as a result? So this case is built around a case called Hunt and Camellia ACHO, which is an Aboriginal health organisation, where a young man whose role was to actually train people in violence, not train people in violence, but train people around violence for young men, did exactly what's described here. And what the Commission held in that case is it is behaviour which will prevent him from working again, given the nature of it. So it goes right to the third limb of Rose and Telstra. So in an investigation, that's why I've raised this. If I was to ask him, I was the investigator, were you charged? He's obliged to tell me the truth. Now, defence could be the Commonwealth discrimination legislation, which says that I'm not allowed, I can't require the disclosure of criminal offences. And the test that sits behind that is unless it is relevant to the inherent requirements of the job. Mm-hmm. Okay? So in this case, if I was an investigator and I asked him about it, or I was the CEO and said, look, I need to know where this occurred. If I failed to answer that and I was the person, I would be in breach for lawful and reasonable direction. So it's a common law obligation. It's a breach of Section 12 of the Fair Work Act, Regulation 107. So it would be serious misconduct for me to fail to do it. And there is no privacy protection that sits around it, given that it adheres in his job that he is able to do this work. And it's on the third limb of Rose and Telstra. So a really hard question, wasn't it? Yeah. It came down to it. Now, next question. This is a really common question. Does an investigator have to wait for the conclusion of the police charges being heard and determined before they form a view? The answer is no. And the reason is because of the difference in the standard of proof. So the standard of proof in a police process is beyond reasonable doubt. The standard of proof in a civil matter is balance of probabilities. Very, very different. One's more than 50%. Mm-hmm. The other ones, there can be no reasonable doubt. There can be no other reasonable explanation. So it's a much higher standard that exists at a criminal level. But it shows you how important the investigation is, doesn't it? Okay? Because what Brigginshaw says, I'm sorry we're using cases, but when I did this morning, it was simple, but I wanted to make sure you understand how complex it actually is. What Brigginshaw says, which is the leading case on the standard proof of civil investigations, that's workplace investigations, is the more serious the allegation, the more satisfied you've got to be of the truth, the better evidence that you've got to be. So you've got the partner, Sarah, saying it happened. Okay. Well, if it was just her that you relied on, you couldn't make a finding. Okay. However, his refusal to answer the question. So this is a piece of evidence law for you. If you refuse to answer a question in such circumstances, then you can draw the inference, okay, that the answer would not be helpful towards them. Okay, that would get you over the Brigginshaw line. You can speak to the police, who will confirm to you that yes, he was arrested. Okay, they won't give you any more details, but if you speak to the local police station, they will assist you to that degree. You can speak to the friends who were there as to his state of intoxication. Okay, there's a whole lot of evidence that you can collect. It may be that you speak to Sarah and Sarah said, yeah, sure, I'll get the neighbours to come. Yeah, they'll tell you the police arrived. So if it was only Sarah's word, you wouldn't have enough on Brigginshaw because the allegation is serious. If it was that he was rude to someone, not so serious, not going to lose his job. But here, he will lose his job and it is a criminal offence that's being alleged. So although it's only the balance of probabilities, there must be real evidence to support it. And his refusal to talk to you about it can be used for that purpose. Okay? So interesting, isn't it? It's not what you'd expect. Can you see why investigations now are so critical in out-of-hours conduct? Can his employment be terminated? Okay? So the answer to that goes directly to Rose and Telstra. So remember the first one is, I've got to do Rose and Telstra on the top of my mind. Is it inconsistent with his employment of contract while he's at work? No, it's not quite there for that. Does it damage the reputation of the organisation? Potentially. So that's the second one. Third, is he unable to execute his contract of employment by the nature of the work that he does? The answer is absolutely. So yes, his employment can be terminated and it is serious misconduct, okay? Why is it serious misconduct? Again, if we go to the definition of what is serious misconduct, it has exactly that test in it, which is, does it create immediate risk of harm to another individual? Quite, because it's not a person who's an employee of the business. To the reputation or financial standing of the business, yes, it does. Is it wholly inconsistent with the nature of the work or contract the person carries? Yes, it is. So Regulation 107B takes it out. So can you remember, don't make stuff up. You've got a beautiful piece of legislation that sets out exactly what tests are for what is serious misconduct. Go and look at it, okay? Common law helps you, but go and look at it. If this is a person who is a fair work employee, go and look at Regulation 107 because that actually defines it. All right, so that is the poll today. And can I say next week, we are going to look at industrial manslaughter across all the different jurisdictions because of the changes that have come through in Western Australia. And we're also going to do our last bit on out-of-work behaviour in relation to criminal conduct outside of work because of the issues that we've recently had raised by you. And also today I thought we really haven't dealt with this at all well, and there is a whole batch of law that sits around that. Okay, guys, that's 11 o'clock. It's time to go. Thank you very much for having us. Good to catch up again.
Yes, you too. Take care. Stay dry, everyone. Keep safe. And we'll see you next week.
Dress differently.
Yeah. Okay. All right. Bye now.